We're here tonight after what has been a very challenging week for the LGBTQ community, and especially the transgender community in North Carolina. Last week, we saw the NCGA ram through a set of laws that we know are flatly unconstitutional. They should never have been in effect, but unfortunately, they are now. And we know that folks have questions about what these laws mean, how they can take action to protect themselves and their families. And I just really want to thank you for being here. Now, I want to start with a message of love and solidarity to trans youth. There's a huge community here to support you tonight, and we're going to walk through some steps that all of these great organizations are taking to fight against these laws and to create a safe and affirming space. Now, I really want to thank our partners in this town hall, Equality North Carolina, the ACLU of North Carolina, Planned Parenthood South Atlantic, and to all the heroic partners, healthcare providers, and advocates working tirelessly in every corner of our state right now. Many of them are here with us tonight. Now we're going to dive into the bill overview. Emma?
Hi, y'all. My name's Emma Chin. I'm with the Campaign for Southern Equality. I'm going to give you all just a really brief overview of House Bill 808. So House Bill 808 prohibits the initiation of gender-affirming care for anyone under 18 in North Carolina, and that includes puberty blockers, gender-affirming hormone therapy, and surgery. It also prohibits Medicaid programs from covering those services. It does not restrict care that has already been initiated. So the bill states that youth who have already begun a course of treatment before August 1st can remain in care. And we know that's vague, and we ask that you ask your provider how they are interpreting that language in order to get some more clarity about what that means for the future of care for your youth. So we've gone over sort of what the law does say. What it doesn't say is that it doesn't prohibit anyone from leaving North Carolina to access care in a state where it is legal to do that. And a court would likely agree that it's unconstitutional to block people from traveling to other states to get care. Further, youth can continue accessing mental health care, which is not restricted or banned by the law in North Carolina. So continuing to access mental health care in North Carolina is completely legal. There will be much more time for questions on any of this at the end, but that's sort of a brief overview of the law. And I'll pass it to Carolyn.
Hi, everyone. My name is Carolyn Jones. I use she, her pronouns, and I work on the Southern Trans Youth Emergency Project with the Campaign for Southern Equality. We just wanted to share a little bit about the project so you all know that there is help out there to figure out what your next steps are for your youth, no matter where you are in their treatment plan. So the Southern Trans Youth Emergency Project is a project of CSE that we've launched across the region in states across the South to provide resources and guidance to families who have been impacted by anti-trans healthcare bans and restrictions. An important thing for all of you to know is that you are not alone in this, and we are here to support you, again, no matter what step you are in your youth's journey. 85% of trans youth in the South now live in states where anti-trans healthcare bans have passed, but that doesn't mean that there aren't options. So when you reach out to us, we can offer support, emergency grants, and navigation services to help you find a provider for your child if you need to. The immediate steps that I'll throw out there for you all is first, as Emma mentioned, just contact your child's current provider if they do have one to discuss care plan and immediate steps and to discuss how they might be interpreting the course of treatment provisions. If your child does not have a gender affirming care provider, get in touch with us and with the STIAP program. We've mapped providers of gender affirming care nationwide, and we can help you identify care, including telehealth options as close to you as possible. When you contact us through STIAP, we're also able to provide an emergency grant of $500 to assist with any needs that your family has as you navigate this time, and to help receive support in identifying care providers in North Carolina and in neighboring access states. So Adam will throw the link to the STIAP program in the chat, and I would really encourage y'all to reach out No matter what happens, there will be options for your child, and we're here to help you figure out what those options are. So I'll look forward to talking to some of you soon, even though I know some of this is really, 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 really challenging, but sending lots of love. And I will now pass things over to Chris Brook, who will talk through some legal overview stuff.
Hey, good evening, everyone. My name is Chris Brook. I use he, him pronouns. I am an attorney in the Chapel Hill offices of the law firm of Patterson Harkavy. It's a real pleasure to have the opportunity to join you all this evening. I wish it was under different circumstances. And as everyone has said to this point, just know that you do have a lot of support out there, even in this exceptionally trying moment. I want to start, I'm going to give a little bit of a legal overview in regards to HB 808. And I want to start with a little bit of a caveat about all of the legal analysis that I'm going to be doing this evening. You know, I'm not involved in any of the litigation teams that are reviewing these bills directly, and that might be bringing challenges. So I'm going to be speaking very generally. The other caveat that I want to offer is that while we have seen a number of these bills in different states that are quite similar, no two bills are exactly alike. So, and no two court systems where bills might be challenged are exactly alike. So just because something has happened in a different court system with a different bill doesn't mean that that's what's going to happen here in North Carolina. As was referenced earlier, these sorts of bills have been popping up throughout the nation, and in particular in the South. Overall, in regards to bills like HB 808 that deal with gender transition for minors, 23 states have passed similar bans. 10 of those 23 are in effect right now. Nearly all of them passed in 2023. There's a very strong track record of challenging these laws and having them ruled unconstitutional. 7 federal judges in Arkansas, Alabama, Florida, Georgia, Indiana, Kentucky, and Tennessee have ruled that similar measures are unconstitutional, as well as the 8th Circuit Court of Appeals, which upheld a preliminary injunction on blocking Arkansas's law. Only the 6th Circuit, which is a quite conservative court, has thus far upheld these sorts of measures. And what courts have said when they have struck down or put these sorts of bills on hold is that they constitute sex discrimination, and they need to have an exceeding persuasive justification, and that there simply isn't that sort of justification for these sorts of laws. And that there's simply no strong basis in medical ethics or in regulating medical care that would permit these sorts of laws to be upheld. And that's why they've been put on hold in a number of these instances. I also just want to reiterate what other people have been reiterating, that if you are in need of assistance, if you're facing a denial of care related to gender-affirming care, we'd like to hear from you, so that you can get support that you need and learn more, and so that we can learn more about your situation. So please contact the CSE team through the STEP project, or email Katie Jennifer from Equality North Carolina at katie@equalitync.org if you are in that situation. And now I'm going to turn it over to Natalie from Planned Parenthood to provide a little bit of a message from Planned Parenthood about the gender transition and the gender-affirming care ban that has been put in place here in North Carolina.
Hi, I'm Natalie Frazier. I'm a nurse midwife, and I'm the director of the gender-affirming hormone therapy program at Planned Parenthood South Atlantic. We are proud to provide gender-affirming care to young people and adults in North Carolina, South Carolina, West Virginia, and Virginia. I want to say that we totally understand how scary and frustrating and upsetting everything that's going on is, and we're here to help. I'm also the parent of a non-binary child, and understand personally kind of how anxiety inducing all of this is. So our intention is to not stop providing care for anyone. We are lucky to have health centers in Virginia and South Carolina, so in bordering states where care is still available. So if you have not started a course of treatment and you need a provider, you can contact us and we can help to navigate you to a health center where you'll be able to access care, hopefully. We do have telehealth services available in those states. So you do have to be physically present in the state where you're having your telehealth appointment, and we have to prescribe to a pharmacy in that state, but we will be able to see patients as long as they're physically present in one of those states. So we can help you to figure that out if you need to. We've got our website and our phone number on the slides, and I think there are some resources we're sharing too. We have a great gender-affirming care navigator who can help you to, navigate any of the extra hurdles that will possibly go along with traveling, or if you have questions about related to continuing care in North Carolina. So yeah, just reach out if you need assistance, and we will do everything we can to help. And then I'll pass it on to Rebby.
Thank you, Natalie and Chris and all. Again, my name is Rebby Kern. My pronouns are they, them, and I'm the Director of Education Policy at Equality, North Carolina. And I'm here to give you some insights on Senate Bill 49, which is known across the country as a Don't Say Gay bill. And we've talked a little bit about this in previous town halls, but reiterating now that this is law, what will happen next. This law is really vague, which makes it very challenging to put into place and to get school districts to align accurately. Particularly vague when it comes to parent notification requirements, which places that weight on educators and school personnel if a young person wants to go by another name or another pronoun, particularly if that name is different than what is listed in the student's record. This includes nicknames for all students of all gender identities, including cisgender students. And so as you can imagine, that's going to put a very heavy weight on many educators. This law specifically prohibits a discussion of gender identity, sexual activity, and sexuality through grades kindergarten up to 4th grade, as well as adding in a new parental consent for opt-in, where it was opt-out, for student surveys. Specifically, the kinds of surveys that are going out to students, which gather protected information. Additionally, this bill also includes library records for parents to get information about their students. So if they've checked out any books, this law would allow families to get access to that. We know that school is back in session. For many folks, your districts might be starting up next Monday, and so this gives very little time to prepare. There is an additional portion of this bill, which can be hard to understand in the context of schools, but this section requires that any minors receiving medical care from professionals receive parental consent. This section also adds unnecessary constraints to the medical system, which those systems are already following best practice medical care for minors. This section does not become effective until December 1st, and there will be more information about that. But I wanted to pass over to my colleague Brennan to talk through a couple of the FAQs that we've gotten so far about Senate Bill 49.
Yeah, happy to jump in here. So my name is Brennan. I work in education policy with Rebby at Equality NC, and I'm based out of Durham. And we're getting a lot of questions about this bill and what its implementation will look like. I think a big one that we've been seeing is, what happens to educators who do not comply by keeping students' gender identity confidential. So what the bill actually says is somewhat limited on this issue. It states that school personnel may be subject to disciplinary action if they encourage or coerce students to withhold information from their parents. So what we know here is that this gives some discretion to individual schools and school districts to determine what actual implementation of the bill will look like. There aren't any further definitions outlined in the law regarding educators, but there is some language that encourages families to sue schools that violate the law. So we have some concern that this law might be aggressively applied to sort of widely silence folks and really intimidate educators and school districts of reducing the amount of LGBTQ affirming lessons or conversations that they're able to have in schools. So another question that I think comes up if we think about the protections that LGBTQ students have is how this interacts with federal law and how we understand Title IX protections for students. So this bill does not deny the fundamental rights of students. We know that it is illegal nationally to discriminate against LGBTQ students and censor conversations about identity, especially when these limitations aren't applied the same way to their peers. So under the US Constitution, public schools are required to follow equal protection under the law. And ideally that would be enforced equally, but students do have freedom of speech rights under the First Amendment, and Title IX fundamentally protects students at schools which receive federal funds from any kind of sex discrimination. So that has been interpreted to cover transgender identity. So this is something to look at and something that folks can file complaints under if they feel that their student has been discriminated against on the basis of gender. So when we're thinking about how folks can support their LGBTQ child, I know that a lot of parents are worried that their student who maybe is already out and is supported at home might be discriminated against because of this law. So we would encourage parents of trans kids to reach out to your school administration to provide clear information about your support and involvement in your kids' education. And this is something that we're happy to provide templates on. Folks in the community have done some really great work in writing out some of the language that folks can use to do that. You also can submit a Power School name change form if your child goes by another name than what is currently in their school records, and that should be honored. So if possible, just make sure to submit written or electronic notification of your child's gender identity and sexual orientation, including their chosen name and pronouns. So I'm going to pass it over to Craig to talk a little bit about how to take action.
Great, Brennan, thank you so much. Craig White, I'm the director of the Supportive Schools program at the Campaign for Southern Equality. I may be the only presenter who gets to do something fun tonight because I have been working with schools and school districts and educators and parents across the South in other states where the government has already passed these laws, or sometimes school districts that have passed similar bills at the district level. And what we've been seeing is the resistance is really taking form in many, many different ways. There are lots of things that we can do. One of the most important things to do is to organize in your school and school district. Find other parents and caregivers who are supportive, find educators, counselors, and social workers, sometimes administrators who are supportive, and act together. Any individual acting alone can easily be targeted, but a group that's organized has a lot more resilience and resistance. I would also say, if students are organizing and taking leadership, then absolutely support their leadership and follow their leadership. And don't push them to lead if they don't want to. A lot of students, what I'm hearing in recent months is they want to keep their heads down and try to survive this bad time. They absolutely have a right to do that. So let's not push them into risks that they're not ready for. As you're getting organized, as Rebbe said, this is a very intentionally, deliberately confusing and complicated bill. That has two purposes from the people that crafted the bill. One is that it really opens this permission to discriminate for hostile school boards and administrators. The other thing that it does is that I think that they're aware many times school administrations can be conflict avoidant or not wanting to get into trouble or not wanting to get sued. And so what we expect to see is a lot of districts over complying and discriminating actually more than what the law requires, because the law is so confusing, but the messaging around the law has not been confusing. So get organized, and as your school district is setting policy to comply with SB 49, get in on those conversations. Speak up for your students, speak up against discrimination, and I'll get to this in a second, but demand that any policies that are set by the district also comply with Title IX and the Constitution and FERPA, which is the Family Educational Rights and Privacy Act. Here are some things, once some district policies are passed, that various educators and administrators have been doing in other states and in some North Carolina counties. One is just saying no. I'd heard this from a teacher today who is queer and out, and she told her principal, Dr. Wheelis, I'm not going to do that, and just left it right there. And so the principal, when the district passes some policy, the principal's going to have to decide whether to discipline that teacher or not. You can take it a step further with what's called a principled refusal. When you refuse to comply with a bill that you think is going to, or a policy that you think is going to discriminate against LGBTQ students. And you can say, I really don't feel like I can follow that policy because it discriminates against transgender students in these ways, which is a violation of Title IX, and I'm required to comply with Title IX. There's also the option for a religious or ethical refusal. This is both old ground. There were Quakers who are conscientious objectors for the American Revolution. It's kind of new in this framework, though, because it's based on some recent Supreme Court rulings, 303 Creative and the Masterpiece Cakes case, that allow people to refuse to serve LGBTQ individuals on the basis of their faith or religious beliefs. Well, if it works for them, then it works for us too. So a teacher can say, I have a religious objection to doing anything that harms children. Or my faith calls me to protect children from discrimination, therefore I can't comply with this policy. How's that going to go over? We have no idea. We are in the woods as far as precedents as far as that goes. But at the very least, it complicates things, not just for the administrators that are trying to enforce hostile policies, but also for some of the anti-LGBTQ organizations that have been pushing the idea that religious bias is an adequate justification for discrimination. Another strategy that we have been seeing, shout out to Union County here, is that sometimes school districts are passing very vague policies in order to hope, in the hopes that teachers will over comply with what they're asking. And so some parents have been using this strategy in Union County to say, exactly what do you mean by that? So, for example, if a district passes a policy that says teachers are required to notify caregivers when they become aware that a student is using different pronouns than those on their birth certificate. Well, the teacher can say, what does become aware actually mean? Does it mean if I overhear them using they, them pronouns? Does it mean they have to put something in writing? But pushing the administration to be very specific about what exactly is required. And then notification. What does family notification mean? Is that a phone call? Is that an email? Is that a letter? What exactly should the letter say? So it's pushing the administration to be really specific. It can be a win-win strategy because if they don't provide the information in writing, then you're not required to comply until they've answered your question about how you can comply. And if they do put it in writing, then you have an opportunity to file a discrimination complaint by saying, you know what, the way you've described this really targets transgender and non-binary students, and that's a violation of Title IX. And then finally, another thing that educators and administrators can do that we've seen is called hostile compliance or malicious compliance, which is complying precisely with the exact letter of the law and policy. So for instance, if a school district based on SB 49 passes a policy that says there can be no discussion of gender identity grades kindergarten through 4. Well, technically using he and she pronouns involves some discussion of gender identity. So what some teachers in Florida did is they pulled every book off their shelves that mentions marriage, because marriage connects to sexual orientation, which was banned, and he and she pronouns connect to gender identity, which was banned. So some teachers were left with, only a couple books on their shelves about the water cycle and the types of volcanoes. Said, hey, that's the education that you're asking for. Is that really what you want? That strategy is hostile compliance. The details of that one depend a lot on what the specific language of the school board policies are. Students, caregivers, and family members. Here are a couple of things that you can do. One is, as your school board is meeting to discuss these policies, you can send the Title IX coordinator for your district what's called a request for determination of Title IX compliance. Okay, a lot of big words. And my team can help on this stuff if you want help with it. But essentially the Title IX coordinator, a lot of them have been trained to receive sexual harassment and sex discrimination complaints. That's what they know how to do. But under the law, one of their major responsibilities is to proactively review every policy and practice in the school district and make sure that it complies with Title IX. A lot of them don't know that. In the urban areas, they're more likely to, but I've come across a lot of, especially rural Title IX coordinators who have no idea that that's their responsibility. If you file that request, part of that request can be, please place a hold on any new or revised policy from the district until you have determined whether it complies with Title IX. So again, for a hostile school board or a hostile administration, this can throw a wrench into the works of their process. We hope to have a sample one of these on the CSE website by the end of the week. If you experience discrimination, based on SB 49 or for any other reason, I think we need to get more comfortable with standing up for our Title IX rights. And so filing Title IX complaints, either at the district level with the Title IX coordinator, or if you're not successful there, you can file a Title IX complaint directly with the Office of Civil Rights. Now, the Office of Civil Rights at the Department of Education is incredibly bogged down. That's not a reason not to file. It could be part of your communication strategy of, hey, transgender students in our school district are experiencing sexual harassment because deliberately misgendering a student is a form of sexual harassment. We have filed 12 complaints on the basis of this against 12 different teachers who have been doing that. The paper might get interested and start carrying that story. Creative resistance is all over the map. There's some beautiful things. A school district that banned teachers from displaying pride flags and safe space stickers. The teachers started to, and no displaying rainbows in your classroom. So the teachers started to line up their books by color to show a rainbow, or make sure the colored pencils are visible and that they're lined up by rainbow, and showing rainbows wherever they could in the room without the flags and the stickers that were banned. Or dress code violations. We've seen some school districts in the Deep South ban students from wearing pride gear, rainbow buttons, and the like. So one thing students have done is they organize 6 of them to wear a solid color t-shirt, and then they just happen to line up as a rainbow or sit down as a rainbow as they went through the day. Take a couple pictures, put it on TikTok or your Insta. And there's all kinds of other forms of creative resistance. Oh, another thing that we've seen a lot of is when a book or a particular curriculum content is banned, a local community center will have a book group or have an open discussion on whatever it is that's been banned. One place we might see that with the curriculum ban in North Carolina, a similar version in Florida, it targets the teachers and their curriculum, and it prevents third parties from coming in to provide that information, but it does not silence students. So in Florida, the ban is kindergarten through 8th grade, and middle school students have really been going to town, taking, whenever they have to do a book report or a science report or a history report, they are picking up something that's banned and bringing it into the classroom themselves. So there is so much exciting stuff that we can do. It may turn out to be a tactical error for the radical right to target the queer community in a culture war, because we're pretty good at culture. Please check the CSC website for more information about these strategies. We would love to hear other strategies that people are trying out and how they're going. This is a very grassroots form of resistance, and I don't think anybody knows yet where it's going to go and what pieces are going to work. Thank you. I'm going to pass it over to Chris again.
Thank you so much, Craig. I really appreciate it. I'm going to talk a little bit more about things that Craig and Rebby and Brennan have previously discussed, which is about some of the very intentional ambiguity and lack of clarity in HB 49. But before I do that, I just want to start by noting the sort of tremendous perverse irony in infringing upon parental decision-making by banning gender-affirming care and then adopting something that you call the Parents' Bill of Rights and overriding a veto at the same time in HB 49. But talking a little bit about HB 49, I'm going to just highlight a couple of passages that are sort of relatively vague, and I think that Rebby, Brennan, and Craig did a good job of sort of explaining why that might be and some reasons why that might be. But you know, one of the ambiguities in the law is what happens to teachers, to school employees that do not comply. It's not entirely clear what will happen to those teachers. Second, you know, the law in HB 49 says that it is impermissible to encourage a child to withhold information from their parents. But when is that impermissible as opposed to just supporting a child in a situation when the parents might pose a danger to the child if the child discloses information about his or her gender identity? And then the law also imposes what it calls a ban on instruction on gender identity, sexual activity, and sexuality from grades kindergarten through 4th grade. Well, what is instruction on gender identity, sexual activity, or sexuality? Is noting that there are gay people to 4th graders instruction on sexuality? Is a teacher who is gay talking, even in passing, about his or her same-sex partner instruction? Is having and Tango Makes 3 in the class library, which is, you know, intended for 3 to 8-year-olds, is that instruction on sexuality that would be swept into the prohibition for that sort of instruction in HB 49? As Craig flagged, a really, really broad reading of these ambiguous and vague provisions would raise serious legal and constitutional concerns about the breadth of HB 49. And Craig highlighted some of the ways that that can be addressed. But I think we have to recognize that a number of these things, we don't exactly know how they are going to be applied, how they are going to be enforced. And I think that, as has been flagged by previous speakers, that's sort of a feature, not a bug, for those who are the proponents of this Don't Say Gay legislation. So if you have faced discrimination, or if you have faced any of these sorts of difficult circumstances where we're not exactly sure how SB 49 is going to be enforced, we'd like to hear from you so that we can learn more about the support that you need and learn more about your situation. So again, please contact the CSE team at adam@southern-equality.org, or email Katie Jennifer at Equality North Carolina at katie@equalitync.org if you're facing this sort of discrimination, or if you're facing challenges about the breadth of HB 49. So with that, I'm going to turn it over to Rebby and Brennan to talk a little bit about the final bill that we're going to be discussing this evening, HB 574.
Thanks, Chris. We're actually passing over to Katie. Yeah.
Thanks, Chris. My name is Katie Jennifer. I use she and they pronouns, and I'm the policy director at Equality North Carolina. I'm going to give a broad overview of HB 574, otherwise known as the Anti-Trans Sports Bill. I am sort of lucky here tonight because this one is probably the easiest to understand out of the three bills that we're discussing. This one is coming directly, as we've seen a couple of years ago, our legislature tried to pass a similar bill, and at that time it didn't go anywhere. This bill is targeting trans girls and women in particular, and it does cover middle school, high school, and college teams. It bases everything on what the bill terms as biological sex, which is not a term that I care for, but it's basically based on what the student's sex is assigned at birth. It does not explicitly prohibit trans boys or trans men from playing on men's teams. The same way that it does explicitly prohibits trans girls and trans women from playing on girls teams or women's teams. But the language of the bill would lead us to conclude that they could, also discriminate against trans boys and trans men in the same way. Next slide, please. So this law has no impact on youth or the adult community in terms of regional sports leagues or anything not affiliated with schools or interscholastic organizations. It does, however, apply to public, private, and qualified non-public middle and high schools that have interscholastic teams, and including intramural teams or intramural activities at the middle school and high school level. It does apply to community colleges, private colleges, and all universities in North Carolina who have intercollegiate athletic teams. And the law does go into effect this school year. It went into effect immediately, which will impact this current school year. Just a minute. Compliance at the middle school and high school level is overseen by the State Board of Education, while compliance at the collegiate level is overseen by the Board of Governors. And I believe I'm passing, I'm sorry. You can see here the landscape of anti-trans sports bills across the country. We're almost split half and half with, I believe it is 23 states enacting a sports ban of some sort and 27 states not implementing a ban at this time. I'm going to pass back to Chris for some of the legal implications.
Thank you so much, Katie. I appreciate it. And I'm just going to very briefly talk about HB 574. There's some overlap with the ban on gender-affirming care legislation that I talked about previously. Again, there's a very strong track record of these sorts of laws barring transgender young women and women from athletic participation being ruled unconstitutional in the courts. 4 federal district courts, which are trial courts, the beginning of the federal court system in Arizona, Idaho, Montana, and Utah, have ruled that these sorts of prohibitions are unconstitutional. The Ninth Circuit Court of Appeals held similarly out in the western portion of the state. And these courts have largely done so on the same grounds. They said, again, that these sorts of bans that target the trans community constitute sex discrimination and also discrimination based on trans identities, and that results in heightened scrutiny. They've also held that it just does not disadvantage cisgender women to have trans women participate, and instead perpetuates discrimination to exclude trans women from participation. So therefore, there's no exceedingly persuasive justification, which is what you need if you're going to be engaging in sex discrimination, to stand up the law that you've put forward. We in North Carolina are in the Fourth Circuit Court of Appeals. West Virginia passed a similar ban on trans girls' athletic participation. West Virginia judge originally blocked that law from going into place, but then ultimately ruled for the state. But the Fourth Circuit stepped in and stayed the trial court, dissolving the preliminary injunction, so kept that West Virginia sports ban from taking effect. West Virginia appealed up to the Supreme Court of the United States at that point, and the Supreme Court of the United States turned back West Virginia's appeal for the moment. So West Virginia's sports ban remains blocked, and that was only dissented to by Justices Thomas and Justice Alito. So we have not only some good law challenging these sorts of measures nationwide, but we have good law here in North Carolina about these sorts of measures that target the trans community. So with that, again, just want to stress to folks that if you've been denied the chance to play sports and are a transgender young person, advocates would like to hear from you so we can get you the support that you need and we can learn more about your situation. So again, please contact Katie Jennifer at Equality North Carolina, at katie@equalitync.org if you're facing those challenges right now. So I believe I have this right. I'm going to be turning it over now to Rebby and Kendra, to Rebby from Equality North Carolina as we start to sum up some of our discussion this evening.
And we're going to pass back to Katie. Thank you. Sorry about that.
My apologies.
It's okay. It's all flexible.
So we're just going to highlight a few action steps from the things that we've just talked about. So one is to get involved in your local school board, encourage your district to actively support LGBTQ youth, consider joining Public School Strong and their training, wonderful training. I've been through it myself as part of Heal Together North Carolina. Has lots of ways for you to get involved and show up at school board meetings to bear witness to what's going on the latest battlefield in this culture war. Also, contact your local leaders for your city, your town, and encourage them to pass a non-discrimination ordinance so that your city or your town protects trans kids' rights to play on parks and recs leagues and those kind of things, so that all sports are no longer accessible to them. Follow Equality North Carolina for upcoming opportunities to mobilize locally. If I had to give a best guess on how I see our information most up to date, I would say our Twitter feed is the most up-to-date and offers a lot of live opportunities to see what's going on, and then Instagram and Facebook as well. Also, if you're part of our mailing list, you'll get any kind of rapid response things that we're looking for. And then ultimately update your voter registration, make sure everything is together there. That's going to be the next battle that we're seeing, ongoing battle, and encourage others to vote in your local elections. This year is a year for local elections, so don't sleep on those school board elections. Get out there and vote. I believe I'm passing back to Carolyn.
Yes, thank you so much, Katie. If you are interested in hosting an event supporting trans youth in North Carolina, we want to support you all. If you want to host a rally, protest, supportive event of any kind, CSE has grants of $250 and other helpful resources to support anyone in the entire state who's interested in hosting an event. So we'll put a link in the chat for the NC is Ready program that we do in partnership with Equality North Carolina, and we would love to help you out if you're interested in hosting anything. So definitely reach out if that's something that you might be interested in and feel like you have the capacity to do right now. And now I will throw things to Allison to close us out.
Thank you, Carolyn. We just want to reiterate right now that we know this is a very, very challenging time for everyone. And we also know that there's ways that we can resist these unconstitutional laws. Many of those we just covered. And I just want to say also that one of the things we battle when these laws come out is misinformation. And I think that's one of the biggest things that we can bring to the table with these town halls and all of our partner groups. Because we know the people here in North Carolina and the groups you've heard from tonight, they're the ones getting things done. So please follow all the social media accounts and all the websites that were given out. Now we are going to go into a Q&A function, and we will end the recording now to help protect